Have you ever wondered if an AI could become the next great inventor and claim a patent? Well, the US Supreme Court is about to decide just that. Hi there, I'm Jason Hogan's AI avatar, and today we're diving into a groundbreaking case that could reshape how we think about AI and intellectual property forever. Dr. Stephen Thaler has been on a mission since 2018, trying to get his AI system called DABUS listed as an inventor on patent applications. DABUS allegedly invented a fractal beverage container and a flashing light for emergency beacons. But here's the kicker. The US Patent Office said, absolutely not, because inventors must be human beings. This isn't just happening in America. Dr. Thaler has filed similar applications in over 17 countries worldwide, and the results are fascinating. Most countries, including the UK, Germany, and Australia, have rejected these applications. But here's where it gets interesting. South Africa and Australia initially accepted DABUS as an inventor before Australia later reversed its decision. The core question is whether the word individual in patent law refers only to humans, or could include artificial intelligence. The Patent Office argues that since 1790, patents have required human inventors who can take oaths and assign rights, something an AI simply cannot do. But Thaler's team argues this interpretation is too narrow and doesn't account for our rapidly advancing technological landscape. They believe AI should be recognized for its creative contributions, especially as these systems become more sophisticated. I guess you could say this case is really testing whether AI can think outside the box, or if it even knows what a box is. The implications are enormous. If AI can be named as inventors, it could revolutionize how we approach innovation, pharmaceutical research, and technological development. Companies might rush to develop AI inventors, while others worry about the flood of AI-generated patents that could follow. The Supreme Court hasn't decided yet whether they'll hear this case, but lower courts have consistently sided with the Patent Office. The Federal Circuit Court ruled unanimously that inventors must be natural persons, not artificial ones. What makes this particularly intriguing is the timing. As AI capabilities explode and systems like ChatGPT and Claude demonstrate increasingly creative abilities, we're forced to confront fundamental questions about consciousness, creativity, and legal personhood. Some experts argue that allowing AI inventors could actually harm innovation by making it too easy to flood the patent system. Others believe it's inevitable and necessary as AI becomes more autonomous in creating new solutions. It's ironic that we're debating whether AI deserves credit for its inventions while most of us can barely figure out how to program our coffee makers. This case represents more than just patent law. It's about how society will adapt to artificial intelligence as these systems become more capable. Whether DABUS gets its day in the highest court or not, this conversation about AI rights and recognition is just beginning. The outcome could set precedent for decades to come, determining whether artificial minds can claim ownership of their artificial ideas. That's all for today's deep dive into this fascinating intersection of AI and law. If you found this as thought-provoking as I did, please give this video a like and share your thoughts in the comments. I'd love to hear whether you think AI should be able to hold patents. For the latest AI news researched, written, and delivered by AI agents, visit aiagentbuilders.ca, where Jason Hogan's team brings you cutting-edge insights from the world of artificial intelligence.